May it please your Lordship. Lordship, in item 7,
Yes.
we have already concluded, your Lordship, the argument. We have also submitted our note of arguments also, your Lordship.
You've already submitted, Your Lordship.
You already.
Yes.
But Mr. Shulai,
Lordship,
if that is your submission, I don't think it will be proper at the mentioned hour to make such submission.
Lordship, I'm sorry, Lordship.
Let the matter be called up.
Lordship.
No, now of course, but later.
Lordship, yes.
Because mentioned hours only for seeking adjournment, mostly, or mentioning of urgent listing, whatever. But more often than not, you see what happens is if such kind of submission is made, we have to pass a proper order.
Lordship.
Mr. Indishulai learned AJ has submitted that the written argument on behalf of the state respondent has been filed. Mr. Learned Counsel for the appellant has submitted that the written argument on behalf of the appellant has already been filed. Accordingly, that is reserved for judgment.
Highly obliged. I'm sorry, your Lordship.
No, it's okay, but at least you could tell your junior
Next time,
colleagues to be here.
Obliged, your Lordship.
Lordship, I'm praying for some time and item number 13 minute. 1-3.
Who's for the other side?
Item number 13.
Any objection?
No objection.
On prayer made by Dr. N. Musical, DSGI, seeking adjournment on grounds of personal difficulty, matters adjourned. List the same after 2 weeks.
Much obliged, Your Lordship.
Lordship, I beg to mention item number 11. May I pray if the matter can come after 2 weeks, my lord. Item number 11, criminal appeal. We are ready. No, 11.
Who's for the appellant?
My lord, it shows senior counsel K. Paul is in the court.
Lordship, this matter is, I'm appearing on behalf of S. Thapa, Your Lordship.
Any objection?
No, Your Lordship.
Prayer made by Mr. S. Sengupta, additional PP, matters adjourned. List the same after 2 weeks.
Grateful.
Highly obliged, Your Lordship.
I beg to mention item 8, Lordship, for 2 weeks. Bring for an adjournment, Lordship. The paper book is yet to be
That
filed.
has been heard.
No, Lordship. This is coming from the
Yes,
BSF
I-
conviction.
But what is required here? I think paper book is to be prepared.
Informal paperwork was required to be filed. It is yet to be filed, Lordship. On the last date, we sought time to file a paper.
How long?
2 weeks, Lordship will file it.
Prayer made by Mr. S. Learned Counsel for petitioner, matters adjourned. List the same after 2 weeks. 3 weeks.
3 weeks, Lordship. Obliged. And Lordship, I also have a prayer for item 15. Here also, Lordship, we were required to file an affidavit. Yet to obtain the relevant documents, Lordship. 1 week's time may be granted.
What is this matter about?
Regarding the, we're seeking stay of the departmental proceeding.
Oh, that
Lordship, the unfortunate thing is that it's been over a month. The order of the charges framed by the trial court copy has not been supplied. So I'm trying to expedite it from the lower court, Lordship. I'm praying for 1 week if it can be taken up after 1 week, Lordship.
prayer made by Mr. S. List this matter after
1 week, Lordship.
1 or 2 weeks. It's up to you. You want 2 weeks?
Lordship,
See, if you
very well,
want,
2 weeks, Lordship,
if
I'll-
you want some time to sort out your other matter,
Lordship.
then
2 weeks, Lordship.
2 weeks.
Much obliged.
Obliged.
Daily list item number 1.
This is against the order passed by Central Administrative Tribunal, my lord. The notice has to go, my lord. It's a response.
What is the case about?
My lord, here what happened, my lord, the petitioner's date of increment was 1st of July every year, my lord. He retired on 1st of January and the learned tribunal was directed to give him one increment. His increment will become due only in July next year, my lord.
Also, he was given an additional increment.
My lord. Because DNI date of next increment was July for him
Yes, I
in his case,
understand.
my lord. He retired on 1st of January. Still the tribunal is directed, there is a factual error in the judgment passed by the learned tribunal.
What about the half year that he has, served?
My lord,
July of the previous year till December?
no, my lord, for half year there is no increment, my lord. Increment is if he completes 1 year.
No mechanism for, calculation of.
No, my lord. Pension it is calculated, my lord, but not increment. For pension, 6 months service is counted as 1 year. But for increment, 6 months, he'll get it only on completion of 1 year's service.
Dr. Leonard DSGI has submitted that what is the impugn order?
At page 14, my lord, this is dated 20th March 2025.
14?
20 March.
No, page 14.
Yes, my lord.
20 March 2025, passed by the Leonard Central Administrative Tribunal, Guwahati bench, is under challenge in this writ petition. However, at the outset, the Leonard DSGI has submitted that notice may be allowed to be issued upon the how many respondents?
Only respondent.
Upon the sole respondent. Accordingly, as prayed for, let notice be issued on the upon the respondent. The same returnable within 2 weeks. This is the matter thereafter.
I'm deeply.
Item number 2.
Here I am appearing for the sole respondent. I will file my affidavit tomorrow because he is now posted Chandigarh. He will come today. Tomorrow I will file the affidavit.
Who is appearing?
Pasha.
None appears for the petitioner. Mr. S. Nath, Leonard counsel for the respondent, has sought for some time to file the counter affidavit. Pray allow, place this matter up to 2 weeks.
Apply.
Item number 3.
My lords, this is the case of the lab assistant from the NIFT. The respondents sought time to file their affidavits on the last occasions, my lord. I have not received a copy.
Who is appearing for respondent? Mr.
Learned DSGI was appearing, my lord. Yeah, item number 3, Shanbol.
Chamberlain.
Yes, Shanbol.
Your Lordship, we are yet to receive instructions in this matter, Your Lordship.
No, have you received a notice?
Your Lordship.
Have you have notice been affected, Mr. Yubin?
My lord, notice has been affected, my lord. They have appeared because there's a.
In fact, by the last order, they have accepted notice.
Yes, because all the respondents, my lord, all the respondents have been. You are appearing for 1 and 2. NIFT, even for NIFT.
Your Lordship, I'll take instructions.
No, how many respondents are there?
My lord, there are 4 respondents.
And they are appearing for?
Respondent number 1 and 2 is the Union of India, my lord. Sorry, respondent number 1 is the Union of India. 2, 3, 4 are the institute, my lord. As a Director General, National Institute of Fashion Technology, and a Director of National Shillong Campus, and a Joint Director, my lord, Shillong Campus. Because on the last day,
It appears that Dr. Muzika has accepted notice on behalf of the respondent.
yes, my lord.
Number
Yes, my lord. That
one.
is yes. That is the reason why he sought time to file an affidavit.
But 2, 3, 4, then you have to affect notice on them.
Uh, Because, my lord, here it appears, because Union of India is a formal party, to so to say, so affidavit won't be required. So 2, 3 and 4 are supposed to file their affidavit, which Dr. Muzika,
Are 2, 3 and 4 represented by Dr. Muzika? No.
it appears that he is going to represent them, has notice on behalf of respondent Union of India, and prays that he may.
He has accepted notice only on behalf of the respondent number 1.
My lord, then, my lord, there is no order of issuing notice also, my lord. In this, there is no order of issuing notice on the last date.
Then you take steps.
My lord. Let there be a specific order, my lord, will take steps.
Mr. P. Ovin, Direct Counsel for the petitioner, has submitted that he may be allowed, that the petitioner may be allowed to take formal steps for issuance of notice upon respondent number 2, 3 and 4 respectively. The respondent number 1, Union of India, being duly represented by the Leonard DSGI. Accordingly, as prayed for, let notice be issued, same returnable within 2 weeks.
2 weeks, madam. Obliged.
Item number 4.
So,
Where were we?
we were going through the evidences, I think. We have actually.
That was long time back.
No, the other day also. But I'll just take your lordship to the statement of the witnesses again. Page 27, Miller. Where's the type copy? 33. Whereas the translation or the typed copy is at page 33, Miller.
PW1.
Yes, Miller. She is probably one of the sisters of the.
Mr. Chakravarti, what is this case about?
Miller, it's a case of murder.
Okay.
In 1991, in the incident occurred in 1991, and after that FIR was filed, it was charge sheeted probably in 1994, and thereafter the trial proceeded at a very slow pace. So finally in 2023, there were 5 accused persons originally. Five, but only 3 remains. The others have expired. So 3 were convicted under 302. So that is the case. Milord, I was submitting here, Milord, that there are contradictions between the statements of the PW1 and the PW3 probably. Anyway, I'll just take your lordship again, Milord.
Okay.
At page 33, your lordship.
Yes.
I know all the accused persons who are present in court today. One Sada Muru, who is now dead, was my younger brother, who died on 16/11/1991. He was murdered by all the above accused persons. I saw the occurrence myself. The occurrence took place around 6:30 p.m. to 7 p.m. on the said date at the paddy field belonging to my mother Kakwen Muru at Lumkudung,
Immediately after the incident, I asked them as to why they killed my younger brother who was not mentally sound. I further asked them why they did not inform me and my family before killing him, and to which they replied that they had already informed my family members, which in fact was not true. I do not know the reason. So in the cross she says, I was at my place of work from 1311 to 1611 at Sung Valley, where I make harvest of my paddy. I reached home on 16/11/91 at about 6 p.m. The paddy of my mother is at Lumkudung village and mine at Sung Valley. From Sung Valley, I reached my house first, then the paddy field of my mother. On reaching home, I took my meal and got ready for bed. Then at that point of time, the accused came and dragged my younger brother. She is saying it is dragged. Other witness says that he was chased. We will come to that. So she is saying it's dragged. Dragged my younger brother to the paddy field of my mother. At that time, my brother, Sadamuru, Kayamuru, Kwenmuru, mother, Nihon Suting, father, were also present at home. Then we did nothing to follow the accused along with our brother, Sadamuru, and asked them not to beat him. I think what he's trying to say is that physically they did not do anything to prevent, but verbally they asked them to not to beat. That is what it appears from there. The distance of the paddy field from our home was about 100 meters. The time when they dragged him from our house is just before 7 p.m. During the dragging process, the accused person also manhandled my another brother, I think, and another brother, Upaya Muru. My father also, Nihon Suting, was assaulted by the accused. We did not inform the headman about the incident on the said date and time, but have, however, made hue and cry, to which none came to the rescue. It is a fact that my brother Usadamuru was left in the paddy field on 16/11/91 to 18/11/91. On being queried as to why she did not take her brother Sadamuru to her home immediately, she replied that her religious practice in a Nyamtre, it is not permissible to carry home a case of a person who met with an unnatural death. It is a fact that my brother Kayamuru reported the matter to the headman of Blumkudung on 18/11/1991, and thereafter a complaint was lodged with the police. I stated that the FIR lodged by my brother is wrong to the extent that I am an eyewitness. I do not know who attacked first the deceased. I was at a distance of about 3 to 4 meters from the place of occurrence. During this winter season on that particular night, it was still visible to the naked eye, though the time was 6:30 to 7 p.m. at night. I was not at all examined by the police. The police examined only my mother, Ka Kmenmuru, and my sister, Ka Solimuru, on 18/11/1991. Subsequently, I was examined by the police and I have told them that the incident took place at 4 p.m. My statement before the police about the time is uneven, and my time before the court about the timing of the concurrence is correct. It is a fact that I never stated before the police that the accused person dragged my brother, Usadamuru, from our residence on the alleged date of occurrence. It is a fact also that I never stated before the police that my brother, Kayamuru, and my father was assaulted and manhandled by the accused persons. It is a fact that my deceased brother was a lunatic. It is a fact that my brother is hospitalized and is in mental jail, Shillong. It is a fact that my deceased brother was a criminal lunatic. It is a fact that only when he was provoked that he became violent. I do not know if my deceased brother destroyed the ripe paddy of the accused. It is not a fact that my brother was not dragged from home on this date and time of occurrence. It is not a fact that my brother and the accused were already in the paddy field prior to the time of occurrence as stated by me. It is a fact that my deceased brother created trouble, and on time and occasion the Dorbashnong directed us to hand over to the police, and thereafter they sent him to mental jail in Shillong. I was not present on 18/11/91 when the police came and inquired into the death of my brother. I do not remember at what time the police arrived at the paddy field of my mother on 18/11/1991. I arrived at the paddy field of my mother at about 8 p.m. on 18/11/1991. I was at home on 16/11/91 at 6:30 p.m. and I went to report the matter to the police on 17/11/91. My brother was not taken to the hospital for post-mortem. Now, the FIR here is dated 18/11. So, although she is saying that she went on 17/11, but there was no FIR lodged on that day. And she also did not lodge the FIR. It is the other witness who lodged the FIR. Now, what is remarkable here is that in front of the family, all the family members were there. Male persons were there. In front of them, there was an assault taking place, but they did nothing to prevent the assault, which is a little difficult to accept. I wouldn't use the term believe. I'll say it is a little difficult to accept that. And another thing is that if they have seen from so nearby, Milord, they should have also seen the instrument, if there is any instrument. Your Lordship will recollect, or I'll take your Lordship also there, in the post-mortem, Milord, the only injury, the serious injury, was that the skull was broken. Now, breaking the skull, Milord, in my humble submission, with bare hands is quite an impossibility, unless some sort of an instrument is used. Now, none of the witnesses have talked about any instrument, nor has any instrument been recovered from the spot or from any one of the accused persons. So, Milord, here another point which I had already submitted, Milord, that she says that the accused was chased. Now, Milord, between the two witnesses, both are siblings, one saying chased, the other saying dragged. That makes a lot of a difference. I mean, so much of contradiction between the two statements should not come in a normal course of action.
And these two are by eyewitnesses.
Two were also there. Both of them were present. Both of them are saying. Well, this is the first witness. She is a sister. Oh, in the FIR, they were not mentioned to be the eyewitness. In the FIR, anyway, we'll go through the evidences first. Then I can refer back to the FIR. Now, PW2 probably, Milord, is the in charge of the Umulong Beach House.
Yes.
So he's only registered the case and directed for investigation. Now, PW3, Milord, is Kayamuru, who is the brother, who says that he was also present there. I received summon to appear and depose before the court today. I know that I'm reading at page 38, Milord. My lord, I received summon to appear and depose before the court today. I know the instant case as the deceased victim Sri Sadamuru was my brother. I cannot remember the date, month and year of the incident. On the day of the incident, I was at home along with my parents and my deceased brother. Well, I can submit here that he was being examined on 8th day of March 2022. That is about 30 years, I think, after the incident. So, I mean, it can be that he may not remember the exact date and all that after so long. But a year at least he should have remembered. After all, there was a death in the family. On the day of the incident, I was at home along with my parents and my deceased brother. At around 6 p.m., one Sri Dal Rinklem came to our house, and after some time he left our house. Thereafter, my victim brother went out of the house and I saw 5 persons chasing my brother. So here he says chasing. chasing my brother and caught him at the paddy field and started assaulting him. On seeing my brother being assaulted, I, along with my parents, rushed to the paddy field to stop those 5, but they still continued assaulting till he died on the spot. So he says that, Lord. He says that he was there and in front of him the assault took place and the person died. I know the 5 persons who have assaulted my brother, and their names are Tigenmuru, Shemuru, Snemuru, Kamaimuru, and Lomitmuru. All belong to Lumkudung village. Today, only accused Shemuru, Tnemuru, and Tigenmuru are present in the court dock. All the accused persons are my cousin brothers. After assaulting my brother, all the accused persons fled away from the place of occurrence. I, along with my elder sister Yongmuru, went to the Umulong Beat house to report the matter to the police, and the FIR was typed by someone whose name I cannot remember now. And I have signed the FIR. Exhibit 1 is the FIR and Exhibit 1 by 1 is my signature. The dead body was guarded till the arrival of the police after 2 days of the incident. The police did some inquiry at the place of occurrence. I do not remember now if the doctor also came to the place of occurrence. Later, the dead body was handed over to us for conducting the last rites. Later, all the 5 accused persons were arrested by the police. Now in the cross, he says, it is a fact that I have informed the police about the incident at about 8 p.m. He says that at about 8 p.m. on that day, he had informed, but no FIR was lodged on that day. It is a fact that whatever I have deposed before the court today is true and correct, and the statement before the police that I was informed by somebody about the incident is not correct. He has filed the FIR. In the FIR, he never said that he was present. I'll take your lordship to the FIR. In fact, now also we can go to the FIR. It is a fact that me and my 4 family members just stood at the PO requesting the accused not to assault the victim, but we did not do anything as we were all scared. It is a fact that only we, the family members, witnessed the incident at the PO and none of the villagers saw it. At the PO, it was me, my father, mother, and 2 sisters, namely Yongmuru and Dinamuru, were present. He does not name the other witness, that's Sadamuru. He does not say that Sadamuru was, not Sada. What is the name of the first one? Oh, Mandamuru, yes. He does not name Mandamuru. The dead body of the deceased victim was lying at the place of occurrence for 2 days from the date of incident. I saw all the 5 accused persons together assaulted my victim brother. I had informed the police about the incident at Umulong Beat house. He is also silent on the use of any instrument. Now, Dr. Poida Thubru is the PW4.
Yes.
My lord, he has done the post-mortem at the place of occurrence only. Now, thorax, walls, ribs, cartilage, etc. all are healthy. Pleura, larynx, trachea, tracheus, right lung, left lung, all healthy. Pericardium healthy, heart healthy, vessels healthy. Muscles, bones and joints, no injury, all are nil. External appearance, condition of the subject normal. Wounds, position, size and character nil. Bruises, position, size and nature nil. Mark of ligature on neck, dissection, etc. nil. In the neck also there is no mark. But if someone is being assaulted with the bare hands, it's expected that there should be some sort of a mark on the neck at least. Abdomens, walls, peritoneum, mouth, pharynx and esophagus, stomach and its contents, small intestine and its contents, large intestine and its contents, liver, spleen, kidneys, bladder, organs of generation, external, internal, all are healthy. Now, my lord, external appearance. Skull vertebrae. The head is broken. So the major injury, the only major injury was on the head, and the skull is broken. Membrano ruptured, brain and spinal cord extused. After examination of the dead body, I found the head is broken, the membrane ruptured, lacerated injury on the chin, and the chin is broken, lower lips disfigured, incised wound on the left supra region measuring 3 by 2 centimeters, upper jaw and 6 teeth broken. I mean, incised wound indicates the use of a sharp instrument. In my opinion, the cause of death was due to hemorrhage resulting from the above injuries. I have also prepared a report after the post-mortem examination was observed. Exhibit 2 is the report, is the post-mortem examination report, and Exhibit 2/1 is my signature. And there was no cross of the doctor. Now, these are the only witnesses, these are the only evidences available. No other evidences. In fact, the headman and others have come and deposed that the other. But I'll just take your lordship to the FIR, Millet, a little before. FIR is at page 1. Yeah, that is okay. 1. At page 1 and page 2, my lord, the English typed copy is at page 2.
Page 2.
To page 6.
Page 6, my lord. Yes, 6 is also the FIR, my lord. Your lordship can come to page 6 also. That was. I beg to inform you that on 16/11/1991, at around 4 p.m. at Lumkudung village, Sri Sadamuru, son of Nihonsuting, Lumkudung, has been murdered by 5 persons from Lumkudung village by the name Tingenmuru, Lovitmuru, Shemuru, Tnemuru, and Sri Kamai Muru. The murderers were all from Lumkudung. Therefore, I request you to kindly look and investigate into the matter and arrest the 5 persons. The witness who witnessed at the time of assault and murder of Sadamuru, Sri Dal Rinkham, and the father of Sadamuru have also been assaulted by these persons. So the witnesses who were named in the FIR, my lord, so these 2 witnesses who have come and deposed before the trial court, my lord, they were not named as in the FIR, in the Ejahar, as eyewitnesses to the incident. And my lord, the other relevant aspect is that no motive has been disclosed by any of these witnesses. That what was the motive for these 5 persons to come and assault these persons to the extent of causing his death. So the absence of any instrument, in spite of the post-mortem report or examination by the doctor indicating that the wound was caused, must have been caused by some instrument. And then the contradiction that one says that he was being dragged, the other says that he was being chased. So that is also a major contradiction. I mean, and then the second, the second bit, that means the third, PW3, although he has stated that who were the witnesses present, but he did not mention about the presence of the PW1. So these are very stark contradictions.
Yes.
What is this? Similar, after that the accused were examined under 313 and they have all denied, they have not given any explanation, but they have denied the accusations. All the accused persons. Then from page 58 onwards, some persons were examined only for establishing that some of the witnesses have expired.
Page?
At page 58, Miller. They are not direct witnesses to the case, Miller. Now, this person, he is the headman of Madur village. He says that he received a summons to appear before the court. He also came on the 30th day of June 2022. I know the witness Srimati Yuka Muru, daughter of Queen Muru and Sri Nihon Sitting, as she was a resident of Madur village where I am the headman. I state that Yuka Muru expired on 13/6/2006 and she was cremated at Madur village on 15/6/2006. So he just came to depose that one of the witnesses has died. I have also issued a certificate to this effect on 19/3/2020 as the family members have not obtained her death certificate. Paper mark 1 is the death certificate and paper mark 1 by 1 is my signature. Now, at page 59, Miller, now the other witness who was named, Miller, who was named in the FIR also, yes, and the witness also stated about his presence, Dal Rinklem. So this person who has come is the son, I think, of Dal Rinklem. I received summon, or daughter, she's a daughter. I received summon to appear before the court and Sri Dal Rinklem is my father. He expired on 7/5/2006 due to his illness and was cremated at the Presbyterian Church Lumkudung Cemetery on 9/5/2006. I have asked for the death certificate from the Secretary, Presbyterian Church Lumkudung, certifying the death of my father. You are reading
page?
Malay, it's at page 59. Bill. This witness name is M.B. Muru. So she has just come to say that her father has died and not available anymore.
She's not a
direct witness to the case. No
eyewitness.
No, nothing. She's not a witness, and she just came to say that Dal Rinklem has died. All these they are not named as PWs also. They were actually, called only to establish that some of the witnesses have expired. Next at page 60 is Emily Muru. She has come and deposed that her father, Nihon Sitting, if your lordship will recollect, he was the father of the deceased also.
Yes.
So Nihon Sitting also had expired in the year 2018 due to old age. So these three persons, about the three other witnesses.
No cross of this.
No cross, nothing, because they are not deposing to the. They have just come to establish that some of the witnesses have. I think the Honorable Court below thought it expedient to have some direct evidence to that. So basically, those are the two major witnesses, they have said, and on the basis of this only the conviction has been done. Here another very interesting aspect is that the IO was never examined, because probably the IO had expired by then.
Okay. So what will be the fallout of that?
Well, the investigation was done, whatever investigation was done by the IO, that has not come before, except for whatever he stated in the charge sheet and all that, which is not part of the evidence, Milord. So, other than that, nothing has come as to what sort of investigation, particularly, Milord, regarding these, whether he found anything regarding the motive and regarding the instrument. Of course, the charge sheet is also silent on all that.
Yes.
So, Milord, the list of witnesses given with the charge sheet is at page 72, Milord. 72, no? Type copy is there. Anyway, this is also readable. I don't see the type copy here. At page 72, Milord, the witnesses who were named, Milord, number 1 is Kayamuru, who has come before the court. Manda Muru, she has also come. Now, Kwen Muru was the mother. She was not available. Yoka Muru, I think she is our sister. She is also not available. Nihon Suting and Dal Rinklem. So these remaining witnesses, none of them were available. All of them have expired. Others are official witnesses. Dr. Thubru, then there was a constable. He was the inquest witness, but he has not come before the court. G.E. Pala was the in charge of Raliang. He came, and S.I.W. Muksor. In fact, the IO has not been named also. There are two IOs, of course, G.E. Pala and Muksor.
Yes.
None of them have come before the Honorable Court. Pala probably, G.E. Pala, the one who did the main investigation, probably he has already expired. So, Milord, I'll take your Lordship to the judgment, Milord. Page 98. Page 98, Milord. So, Milord, this was before the Honorable Sessions Judge West Gentia Hills.
Yes.
The accused was represented by a state defense counsel from there only. Also, he is my namesake, but it was not me. It was someone from there.
Okay.
And final hearing was on 1/8/23, and the date of order is 4/8/23. The criminal proceeding in the instant case was set in motion 3 decades ago by Sri Kaya Muru, brother of the deceased Sada Muru, by filing an FIR dated 16/11/1991, alleging that 5 persons, namely Sri Tengen Muru, son of Wu Kyang Suting, I think this name actually, Kyang Suting, Sri Luit Muru, son of Wu Kyang Suting.
You're reading page what?
Page 99, Milord. The judgment.
This is
So 5 persons, Sri Tingen Muru, son of Kyang Suting, Sri Lohit Muru, son of Kyang Suting, Sri She Muru, son of Kyang Suting, Sri Tne Muru, son of Kyang Suting. So these 4 are brothers. Then Sri Kamai Muru, son of Upil Luden, from Lumkudung village, murdered Sri Sada Muru, son of Nyahan Suting of Lumkudung village on the 16th of November 1991 at around 4 p.m. Now FIR said 4 p.m.
yes.
but the witnesses said around 6:30 to 7 at Lumkudung village. It was further alleged that all the murderers were from Lumkudung village and Sri Dal Ringklem and father of Sadamuru were the witnesses to the assault by the accused persons. So in the FIR, these other witnesses who have come and said that they were witnesses, they were not stated to be the, even the person who filed the FIR, Kayamuru, he has come and deposed before the Honorable Court, but he also has not said in the FIR that he was an eyewitness. That is a little strange, because if the incident had happened in front of his eyes, he would be expected at least to disclose that much in the FIR. The FIR was lodged before the officer in charge, Umulong Beat House, Joy, which was forwarded to Joy Police Station on 18/11/1991 and registered as Joy PS case number so-and-so under 302 and 34 IPC. The case was taken up for investigation by in charge Umulong Beat House, SIQE Pala. The order sheet reveals that the 5 named accused persons in the FIR were arrested on 19/11/1991 and released on bail by order dated 3/12/1991. The IO found the dead body of Sadamuru on 18/11/1991 after 2 days. IO police had come to the place of occurrence after 2 days. Now during these 2 days, what has happened, there is no direct evidence on that. They found the dead body of Sadamuru on 18/11/91 in a decomposed state. Post-mortem was conducted at the place of occurrence. The investigation culminated into a charge sheet, being charge sheet number so-and-so dated 14/5/1994 under 302/34 IPC against all the 5 named accused persons. The IO, relying on the statement of the 10 witnesses, filed the charge sheet. It is pertinent to mention that the charge sheet was filed before the Additional Deputy Commissioner, Joy. After filing charge sheet on that was before the separation of the judiciary. After filing charge sheet on 1/3/1995, copies were served to the accused persons in compliance with section 207 of the CRPC. Charges were framed against all the 5 accused persons on 22/5/1995. The 5 accused persons pleaded not guilty and demanded for a trial. The accused Kamai Muru died during the course of the trial on 18/8/2018 and he was declared dead video order dated 14/2/2020. The accused Lohit Muru reportedly died during the course of trial. However, there is nothing on record showing that Lohit Muru has been declared dead. The trial proceeded against the accused Tingen Muru, She Muru and Tne Muru. From the record, it emerges that after framing of charge on 22/5/1995, the matter was posted for evidence till 31/5/2005. For 10 years, no witnesses were examined. Thereafter, on 11/7/2005, the case was transferred to Fast Track Court Joy for disposal and the matter was posted for evidence before the Fast Track Court. The learned Fast Track Court video order dated 17/3/2010 has observed that the matter was posted for evidence 10 years. For 10 years, no witness has been examined due to the non-appearance of the accused. The matter was again posted for evidence. No witnesses were examined. After the separation of the judiciary from the executive, In the district of West Jaintia Hills District, Joai, the case was transferred to this court on 17/9/2015. This court video order dated 29/10/2015 posted the matter for evidence and appearance of the accused. Learned Counsel Sri S. Chakraborty was appointed as State Defence Counsel. Video order dated 12/1/2016 to represent the 4 accused. Now, my lord, here if I can just Mandamuru, page 33. My lord, the date of examination of Mandamuru, the PW1, my lord.
PW1.
I'm just Mandamuru was examined on 6th of August 2001. 2001. So here this finding of the Honorable Judge that no witnesses were examined when the matter before the ADC before the separation. Actually, PW1 was examined before the separation of the judiciary when the matter was still with the ADC and even before the matter was referred to the fast track court. It was done at the time of the ADC ADM's time only. And we'll go back to page 101, Miller. Para 4. The order dated 14/2/2022 reveals that the accused Kamaimuru expired on 11/8/2018. PW1 was examined on 6/8/2021. Yes, Philip. In the examination of witnesses 201. Anyway, there is some that is not very relevant. He was examined. That is, PW1 was examined on 6/8/2001. PW2 was examined on 3/2/2022. PW3 was examined on 8/3/2022. PW4 was examined on 21/3/2022. The remaining witnesses expired and could not be examined during the course of the trial. The witness Yukimuru died on 13/6/2006. Daldinclem died on 7/5/2006. Witness Nihon Suting died in the year 2018. Witness Kumar Khongir died on 19/11/2010. The IOQE Pala died on 6/11/2022. The prosecution during the course of the trial examined only 4 witnesses. Thereafter, the 3 accused persons were examined under 313 on 22/6/2023. The accused persons were given an opportunity to bring defense witnesses. They declined to bring defense witnesses. As such, the matter proceeded for final hearing. Heard, learned additional PP Sri So and the learned counsel So representing the 3 accused persons. Now, prosecution's argument. Learned additional PP submits that the evidence of PW1, brother of the deceased Sadamuru, clearly reveals that he was present and he saw the 3 accused persons had murdered his younger brother Sadamuru in the paddy field, and he is the eyewitness to the incident. The evidence of PW1 corroborated with the evidence of PW3 Kayamuru, who is also the brother of the deceased Sadamuru. PW3 also saw the 5 persons took his younger brother Sadamuru to the paddy field and assaulted him. The evidence of the doctor corroborates with the evidence of the PW1 and PW3. The post-mortem report clearly reveals that the death was caused due to hemorrhage from the injuries. The prosecutor fairly admits that vital witness could not be examined during trial as they expired. However, with the evidence on record, the prosecution has clearly established that the accused persons named in the FIR had assaulted Sadamuru, causing bodily injury, resulting in the death of Sadamuru. As such, the prosecution has established the charge beyond reasonable doubt and prays for conviction of the 3 accused persons under section 302. Now, my lord, from the argument of the prosecution, it is very clear that they were relying only on these 2 witnesses. That means PW1 and PW3. Yes. These are the only 2 witnesses have been relied upon, and on the basis of that only the prosecution sought to establish its case.
Yes.
Now, the learned State Defence Counsel, we are at page 104, Miller.
Page.
Page 104, Miller. The defence arguments.
Yes.
Malad. The learned State Defence Counsel, so at the very outset, submits that the witness PW1 and PW3 are brothers of the deceased Sadamaru. As such, they are interested witnesses and their evidence cannot be relied without any corroboration. Learned State Defence Counsel further submits that there is inconsistency in the evidence of PW1 and PW3. So that was pointed out, Miller. PW1 stated in his evidence that the deceased was dragged from his house. However, PW3 stated that he saw the 5 accused persons chasing the deceased. The defense counsel further submits that there is no evidence on record to show that the witness PW1 and PW3 were present in the house when the alleged incident took place. The State Defence Counsel has also contended that the post-mortem report reveals grievous injuries on the body of the deceased and it is not possible for causing such injuries with bare hands. Further, the State Defence Counsel submitted that the IO has not been examined in the instant case and in the absence of the evidence of the IO, prosecution case is not sustainable. Learned Defence Counsel summed up his argument, stating that there are serious doubts if the accused persons had committed the offence, as such prays for acquittal of the 3 accused persons. Upon hearing the rival counsel and on examining the material on record, this court finds that there has been delay in trial which has led to the death of the witnesses. Consequently, vital witnesses could not be examined. However, there is adequate evidence on record which require examination of this court to determine if charges has been established by the prosecution against the accused persons beyond reasonable doubt. On scrutiny of the evidence on record, following points emerge for determination. Point for determination, number 1, whether PW1 and PW3 were present in the house at Lumkudung village along with the deceased Sadamuru on 16/11/1991, and PW1 and PW3 saw the 5 accused persons causing bodily injury to Sadamuru in the paddy field of their mother. Whether Sadamuru died due to the bodily injuries caused by the 5 accused persons in the paddy field. This is vital here, my lord. Whether the accused Tingenmuru, Chanemuru and Shemuru had committed culpable homicide amounting to murder. Decision and the reason thereof. First point, whether PW1 and PW3 were present in the house at Lumkudung village. The FIR in the instant case was filed by PW3, albeit the date in the FIR is shown on 16/11/91. However, it was received on 18/11/91. So, FIR was filed on 18/11/91 by the PW3. PW3 had confirmed his signature in the FIR. Exhibit 1 by 1, the FIR was typed by somebody and he has put his signature. From the evidence of PW3, it is clear that he has filed the FIR and the 5 accused persons were named in the FIR. That with regard to the date in the FIR and the date received of the FIR, PW3 has stated in his evidence that the body of the deceased was guarded for 2 days at the place of occurrence till arrival of the police. Now, Milord, here this guarded at the place of occurrence, Milord, I mean, that has, in my respectful submission, that has not been established, Milord. Till arrival of the police, PW1 has stated in his cross-examination that as per the local practices and customs in Nyamtare religion, if a person dies of unnatural death, his body is never brought home As such, the body of the deceased was kept at the place of occurrence for 2 days. The above evidence of PW1, PW3 explains why the body of the deceased was kept for 2 days at the PO, and the variation in the date of FIR, that is 16/11/91, and the date of receipt of the FIR, 18/11/91. PW1 has stated in his evidence that the deceased Sadamuru was his younger brother who died on 16/11/91, and he was murdered by the 5 named accused persons. PW1 has categorically stated in his evidence that he saw the occurrence. The relevant part of his evidence is reproduced below. I saw the occurrence myself when the incident took place at around 6:30 to 7 p.m. in the paddy field belonging to his mother, Queen Muro. Here, let me pause for a moment, Millard. Here, the Honorable Court below has totally ignored the fact that in the FIR, he is admitting, the PW3 is admitting that he has filed the FIR, but he has not given any good reason as to why in the FIR he said that the incident occurred at 4 p.m. He just says that that is not correct, this is correct. But why did he give that wrong information in the FIR? And secondly, that he has stated who were the persons present there in the FIR, but he did not give the name of the PW1. Now PW1 comes and says that she was present, but although names of the persons present were there in the FIR, but PW1's there. So these all.
What difference will it make? You see, with the contents of the FIR and the eventual, evidence, or
it casts a doubt, Millard. It casts a doubt on the authenticity of the evidence. That is my submission, Millard. That is my submission. Millard, at least that much is expected, that if the person who has filed the FIR, at least in what he has written in the FIR and what he is stating before the Honorable Court, Millard, this should tally, Millard. So that casts a little doubt. That is in my respectful submission, Millard. So, PW1 stated in cross-examination that the accused persons came and dragged his younger brother to the paddy field of his mother. And at that point of time, his brother Sadamuru, Kayamuru, Kakwenmuru mother, who Nihon shooting father, were present at home when the accused were beating his brother Sadamuru. The brother asked not to beat him. The distance of the paddy field from the house is around 100 meters. The accused persons had also manhandled the father of the deceased, Nihon shooting. That was never in the charge sheet, in the investigation. This never came out. PW1 stated that there was hue and cry when the incident took place. However, nobody came to the rescue. Further, PW1 stated in his cross-examination that he was at a distance of 3 to 4 meters from the place of occurrence, though it was winter and night. However, it was visible and PW1 could catch sight of the incident. The evidence of PW1 in cross-examination that he along with PW3 were present in the house corroborates with the evidence of the PW3, who stated that on the day of the incident he was at home along with his parent and deceased brother. So that contradiction, Millard, which is there regarding dragging and saying, and also about the presence of the persons who were there, that has not been taken into consideration by the Honorable Court below. In cross-examination, PW3 stated that he was present when the incident took place and requested the accused not to assault his brother. They did not intervene as they were scared. He further confirmed in the cross-examination that the family members had witnessed the incident. PW3 confirmed that he saw the 5 accused persons together assaulted his brother Sadamuru. The evidence of PW1 and PW3 clearly establishes that they were present in the house on 16/11/1991. In cross-examination, it has been confirmed that PW1 and PW3 along with his mother and father. They were present in the house. So the differences in the statements, these were never taken into consideration by the thing. The differences in the contradictions between the FIR and the statements, those were also not taken into consideration. The Honorable Court below has taken the statement of the witnesses to be the ultimate truth, without really trying to examine whether there is any circumstances which tend to cast some sort of a cloud on their statements, which in my respectful submission are there below. In cross-examination, PW 145 is evidence that he saw his brother being beaten by the accused person and asked the accused persons not to beat him. PW 3 deposed that he saw the 5 accused persons chasing his brother and caught him at the petty field and started assaulting him. On seeing his brother being assaulted, PW 3 along with his parents rushed to the paddy field to intervene. However, the 5 persons kept on assaulting Sadamuru till he died. Now, the evidence of PW 1 and PW 3 establishes that on 16/11/1991, they were present in their house at Lumkudung village between 6 p.m. and 7 p.m. The evidence of PW 1 and PW 3 has not been shaken. On contrary, it has been confirmed in cross-examination that they were present in the house on the day of the incident. PW 1 and PW 3, through their direct oral evidences, has established that they saw the 5 named accused persons. Now, that why the accused, the witness number 3 had written something in the FIR and something else he is saying before the thing, that no clear answer was given. But that aspect of it has been, the Honorable Court below is completely silent on that, has not taken that aspect into consideration at all. Whether Sadamuru died due to bodily injuries caused by the 5 accused persons. Now, here also, my lord, this is the second question for determination before the court, as framed by the Honorable Court below, that with regard to the above point for determination, the prosecution case revolves around PW 1, PW 3 and PW 4. PW 4 is the doctor, if your lordship is recollect. This court had already discussion above that. The prosecution has established that PW 1 and PW 3 were present at their house at Lumkudung village when the incident took place. PW 1 saw the occurrence which took place in the paddy field of their mother at Lumkudung village. In cross-examination, PW 1 fortified in his evidence that he saw his brother being beaten by the accused persons and asked the accused persons not to beat him. PW 3 deposed that he saw the 5 accused persons chasing his brother and caught him at the paddy field and started assaulting him. On seeing his brother being assaulted, PW 3 along with his parents rushed to the paddy field to intervene. However, the 5 accused persons kept on assaulting Sadamuru till he died. PW 3 has named the 5 accused persons who assaulted his deceased brother, Sadamuru. The evidence of the PW 1 and PW 3 corroborates that the evidence of the doctor who conducted the postmortem on the body of the deceased and prepared a report. After examination of the dead body, PW 4 found the injuries herein as under. He has repeated this, whatever was the finding of the doctor. Head is broken, membrane ruptured, lacerated injury on the chin is broken, lower lips disfigured, incised wound on the left supratemporal region measuring 3/2 cm, upper jaw and 6 teeth broken. Incidentally, your lordships, the postmortem is report, although the postmortem was conducted about 2 days after the alleged incident, but the postmortem report is silent on the time of the death. Normally in a postmortem report it is indicated that the death has occurred how long ago. In this particular report, neither has the doctor given any indication regarding the time of death. But that becomes very relevant because it is an admitted situation that for 2 days, either the person or the body, if he has died, then it is the body. If he has not died, then it is the person who was there at the field. Now, when did death take place? Did the death take place on 16th, or did the death take place at some other point, some other time in between the 16th and the 18th days? So that is not clear now in the post-mortem report, which probably, my lord, should have been clearer. And no reason has been given also that why that aspect of the, that very relevant aspect has not been taken into.
What was the state of the body?
Body, my lord,
Decomposed.
Decomposed.
they said decomposed. I mean, my lord, I can take your lordship to the post-mortem report. Doctor's statement, my lord. PW4. At page 40, my lord. I received summons to appear and depose before this court today via BC, as I am not in good health and not in a position to personally appear before this court. I joined service in the year 1980. I am reading at page 40, lordships.
Yes.
And was posted at Umulong Dispensary. In the year 1991, I was posted at Joy Civil Hospital. I received a requisition from the police to conduct the post-mortem on dead body of Sri Sada Muru, male, aged 23 years, at the spot or place of occurrence, which is the perifield of the deceased mother, Kwen Muru. The examination was conducted on 8/11/1991 at 2 p.m. Now he goes on to describe the conditions of the different internal organs and also of the external appearance. He says, Millard, at page 41, the second part, Millard, external appearance. Condition of the subject, normal. He did not say decomposed. Wounds, position, size and character, nil. Bruises, position, size and nature, nil. Mark of ligature or neck, dissection, etc., nil. Then again goes to the other aspects of the internal organs, and then external appearance regarding the skull. Well, death was caused by the injury in the skull. That is very clear. If you can go back, lordships, to page 112. So, doctor's evidence does not clearly say that the body was decomposed, nor does it give any indication regarding the time of death and as to why the time of death could not be indicated or ascertained. Now, if your lordships come back to page 112, on the part of the judgment, para 2.2. So, on the top portion, the doctor PW4 opined that the cause of death was due to hemorrhage resulting from the injuries. Now, 2.2. The evidence of PW1 and PW3 are in nature of direct oral evidences and they are eyewitnesses to the incident. The fact that the 5 accused persons had caused injuries to the deceased Sadamuru is established by direct oral evidence which remains unshaken. Direct oral evidence cannot be looked with any suspicion unless some glaring contradiction is brought about. Now, Millard, there are glaring contradictions. Contradictions are contradictions, Millard, and glaring would indicate that contradictions are apparent on the face of it. Now, as I have already submitted, Millard, there are certain very clear contradictions between the statements. The direct oral evidence of PW1 and PW3 who had seen the incident finds corroboration with the evidence of the doctor PW4 and the post-mortem report. Now, how? Doctor clearly said there is an incise wound. Incise wound indicates the use of a sharp instrument. But here the witnesses have never said anything about the use of any sharp witnesses. And this gap of 2 days between the post-mortem and the thing and the date of Milord, in my humble submission, this is enough to cast a very serious doubt on whether the death was actually caused by the incident which these persons are saying. And moreover, the statements, the contradictions in the statements of these two persons and with the FIR, these also indicate that, or cast a doubt rather, whether these persons were actually present at the place or not. The evidences of PW1, PW3 and PW4 being examined together with post-mortem report convincingly establishes that the 5 accused persons had caused injuries to Sadamuru on 16/11/1991 in the paddy field of Lumkudung village. The defense contention with regard to the time in the FIR is a minor variation. My lord, how a variation? He says 4 p.m. and then he comes and says it is 6:37, and that was only 2 days after the incident that he was filing the FIR. How could he go to the extent of making such a glaring mistake, my lord? And then he says it is a minor variation of 2.5 hours to 3 hours, my lord. The defense contention with regard to the time of the FIR is a minor variation, and the witnesses PW1 in his cross-examination has clarified that the timing stated before this court is the correct timing. But he did not clarify that why he gave a wrong timing in the FIR. The fact remains that in the FIR the timing was given is different. The second contention of the learned defense counsel that the witnesses PW1 and PW3 are the brothers of the deceased, as such they are interested witnesses, is dealt with. From the evidence of PW1 and PW3 it emerges that their presence in the house in the evening was natural, and nothing has been brought on record to show that PW1 and PW3 had some oblique motive to implicate the accused persons in the instant case. Now, my lord, instead of considering the motive behind the murder or behind the assault, or why should the person have been assaulted, he is considering the motive of the whether these PW1 and PW3 had some oblique motive or not. Now, my lord, that is a little abnormal, if I may, unusual. In Harban's Kaur versus State of Haryana, it was held in Para 7, there is no proposition in law that relatives are to be treated as untruthful witness. That, my lord, I do not insist on that point also. I am not, although that was raised by the defense counsel, but I am also not saying, witness is a witness, unless...
what matter is the quality of
quality of the evidence. So I am also not contradicting or not asserting that point, my lord. On contrary, reason has to be shown that the plea of partiality is raised to show that the witnesses had reason to shield the actual culprit and falsely implicate the accused. In the instant case, the deceased Sadamuru was the brother of PW1 and PW3. The post-mortem report reveals that it is a case of homicide. There is no iota of evidence from where any dim inference can be drawn that the witnesses PW1 and PW3 with some ulterior motive has implicated the accused person. On the contrary, the brother of the deceased ordinarily will never like to shield the real culprit and implicate falsely innocent persons. The argument of the learned defense counsel that PW1 and PW3 are interested witnesses is without substance and does not germinate from the evidence on record. Now, that I am leaving it as it is. The other question which has cropped up is whether non-examination of the IO and other witnesses is fatal to the prosecution case. It would be gainful to comprehend that in a criminal trial, it is the quality and not the quantity of the evidence which is necessary for proving or disproving facts. Corroboration is a rule of prudence. Section 134 of the Evidence Act comes to the aid to resolve the doubt. Section 134 of the Evidence Act envisages no particular number of witnesses shall in any case be required to prove for proof of any fact. It is reiterated that it is the quality of the witness and not the quantity of the witness which is necessary for proving or disproving the fact. It will be gainful to take aid of the law laid down by the Honorable Apex Court to comprehend the proposition of law and requirement of number of witnesses for conviction. This Milord, I'm leaving it. I mean, I'm not reading this. This is settled law. Para 116, page 116, paragraph 2.3. On analyzing the law discussed above, it is crystal clear that it is in a criminal trial the legal system demands value, weight, and quality of the evidence. On this, I am in total agreement, Milord, with the Honorable Court below. Only thing is that I am submitting that the quality of the evidence which was produced before the Honorable Court below, it was not above board, to say the least. As stated earlier, corroboration of the witnesses become necessary when the evidence of the witnesses are not wholly reliable. The evidence of PW1 and PW3 being in the nature of direct oral evidence does not require any corroboration and can be acted upon for the purpose of conviction. Non-examination of the IO is not fatal for the prosecution case if the other evidence establishes the prosecution case. The prosecution through the evidence of PW1, 3 and 4 has convincingly established that Sadamuru was inflicted severe bodily injuries and he died due to the injuries inflicted by the 5 accused persons. So this is the major finding below. Here, Milord, the court has, Honorable Court below has been totally silent on the absence of any recovery of any instrument or even no statement by the witnesses regarding any instrument being used, although the doctor's report clearly indicates that a sharp instrument must have been caused, Milord.
Yes.
Milord, when the witnesses have not said this specifically, in my humble and respectful submission, the witnesses did not see the accused persons use any sharp instrument. If they had seen any sharp instrument being used, so they would have surely stated it before the court and in their statement to the IO. They have never said, that means they did not see. That means these 5 accused persons, even they have bodily assaulted, which is not admitted, but I am just saying, assuming. Even in that case, Milord, the fact remains that it's established that no sharp instrument was used by these 5 persons. So there is a contradiction between the findings of the post-mortem report and then this statement of the accused. So the Honorable Court's findings on this regard do not seem to be accurate. From the discussions above, I'm at page 117, Your Lordships, on the third point.
Yes.
From the discussions above on the point number 1 and point number 2 for determination, the prosecution has established that PW1 and PW3 were present in the house when the incident took place. PW1 and PW3 saw the 5 accused persons causing bodily injuries to the deceased Sadamuru, and the deceased Sadamuru died due to the bodily injuries suffered by him. This last part, that died due to bodily injuries suffered by him, this, in my humble and respectful submission, Milord, has not been conclusively established, in particular taking into consideration the post-mortem report, the clear findings in the post-mortem report. Culpable homicide coupled with intention and knowledge that the injuries is sufficient to cause death amounts to murder and is punishable under section 302 IPC. Mens rea, he's talking about mens rea. That is the act of beating, Milord. Now, Milord, to establish mens rea, motive is also a very relevant aspect. Yes. Why should they have had the mens rea of killing the person? Milord, that is not shown. Milord, it may be that they had beaten, but was it to the extent of causing the death? And that too, Milord, when the family members were present, and in their presence, if the assault was to that extent, then would the family members, just on the plea of they themselves being afraid of the accused persons, would not have interfered in the matter, Milord? And then the glaring difference in the time, Milord, that 2 days period, that is also very relevant. Culpable homicide coupled with intention and knowledge that the injuries is sufficient to cause death amounts to murder. From the evidence of PW 1 and 3, it emerges that the 5 accused persons caught hold of Saddam Muru, dragged him to the paddy field. On this point also there is a contradiction, whether dragged or pulled. Dragged or chased. PW 1 and PW 3 pleaded not to harm Saddam Muru. The 5 accused persons went on with the brutal act and had beaten Saddam Muru till he died. Now, Milord, this is not corroborated by the post-mortem report. Unfortunately, the father of the deceased could not appear before this court to depose. PW3 had stated in his evidence that the accused persons after the incident fled away from the PO. He also stated that on seeing his brother being assaulted, he along with his parents rushed to the paddy field to stop the 5 accused persons, but they continued to assault him till he died on the spot. This evidence of PW3 remains intact. I mean, as I have already submitted, Milord, this has not been conclusively established. The deceased was inflicted injuries by the 5 accused persons in the paddy field till he died. Now he is taking it to be an ultimate truth, the statement. The other relevant aspects of the case, Milord, to determine the authenticity of the statement, those have been totally overlooked by the Honorable Court below. The post-mortem report and the evidence of the PW4 reveals that the injuries were inflicted on the face and on the head of the deceased. The cause of the death was due to the injuries. Here also he is totally silent on the finding on the post-mortem report that there was an incisive injury. The evidence on record clearly establishes that the 5 accused persons had inflicted the injuries on Saddam Muru with an intention to cause his death. Milord, this finding, Milord, is going a little beyond the evidences which are on record. The prosecution has established that the accused persons Tengen Muru, Tne Muru and Sne Muru had caused bodily injuries intentionally, which was sufficient to cause death of Saddam Muru. The 3 accused persons who stood for trial has been on denial. In their statement under 313, no explanation has been forwarded by the accused persons on the incriminating evidence which has come during the course of trial. It is a settled law that there cannot be any evidence of intention, but it has to be inferred from the established facts. Intention and motive are two different things. By intention, probably he is talking about mens rea. Mens rea I do not dispute, Milord, but mens rea also has to be found, Milord. The whole question is, of course, here, Milord, even assuming that there was an assault taking place at that time, but was it for the purpose of causing death? That question remains open, more so because the time of death has not been clearly established. The facts which has been established that the injuries were caused by the 5 accused persons, which was sufficient to cause death of Saddam Muru. This also sufficient to cause death of Saddam Muru, and the nature of the injuries established by the Exhibit 2 only manifests that the injuries were inflicted to cause death. That for the reason discussed above, this court finds that the prosecution has established the charges beyond reasonable doubt, and the accused so-and-so, Tengen Muru, Tne Muru and She Muru are found guilty and convicted for an offence of murder amounting to culpable homicide under section 302. So this is the finding, Milord, and On the sentence, there was a hearing, and that is on the in the next page 122, Miller.
What do you have to say about the sentence?
Sentence, Miller, here they have given Miller, the defense counsel had submitted, in all fairness, that if it is proved that 302 is the thing, then life imprisonment is the minimum punishment for an offence under 302. As the prosecution is praying for minimum sentence, the defense counsel has nothing much to say. So that was the thing, and it has been. The 3 persons are sentenced to life imprisonment. Now, Miller, here, Miller, the whole findings is on these two statements only. Other aspects, especially on the absence of the instrument, Miller, the judgment is totally silent. It is totally silent, although the post-mortem report indicates that some sort of an instrument must have been used. And the court below also has gone beyond the evidence in stating that the injuries caused by these people only has caused the death. And thirdly, Miller, whether these 2 eyewitnesses, whether it is totally reliable or not, that is also questionable in view of the contradictions which have been pointed out, Miller. So, in my respectful submission, this is a fit case for your lordships to, what was this? Anything here? So, it's a fit case for your lordships to exercise your lordship's jurisdiction as appellate authority and intervene in the matter, Miller. And my respectful submission, that is a fit case for the accused to be acquitted also. Oblige, your lordship.
Yes.
May I please, your lordships. Lordship, before I make my submission, my lord, there are 2 things has to be noted, my lord, before I start my argument, my lord. Firstly, my lord, this is a case of direct ocular evidence and not a case of circumstantial evidence. Why I say that, my lord? This will have a bearing on the non-mentioning of the, my lord, date and time of death, my lord. Now, secondly, my lords will notice here, my lord, that the witnesses here, my lord, and the place of occurrence, the person where died, my lord, is from a remote village, meaning thereby, my lord, witnesses here are rustic village witnesses, my lord. Why I say that, my lord? Because of that, my lord, there is bound to be some contradictions. That is further fortified by the fact that, my lord, the statements of the witnesses were, my lord, recorded after 20 years of the date of occurrence, my lord. So, my lord, human mind cannot be like playing a tape recorder, my lord, rewinding and playing it again. There is bound to be, my lord, some contradictions, my lord. Now, coming to my submissions, my lord, my argument. Here this is a case of, my lord, direct ocular evidence. There are two eyewitnesses here, my lord. PW1 and PW3, my lord. Now, to avoid the, my lord, repetitions, my lord, what my learned senior had submitted that PW1 had stated in his chief that the accused person had, I saw them dragging my deceased brother, my lord. And in the contradiction that was brought out was that PW3 stated that I saw my brother being chased, dragging and chased, my lord. But, my lord, the more important aspects of the, my lord, statements were not put before your lordships. That is, my lord, PW1, my lord, in his statement had categorically stated that at that relevant point of time, at the time of occurrence, my lord, he was at the house with his parents, and the accused person came and dragged his brother from the house. And he also, now in the PW3, my lord, PW3 states that, my lord, the distance between the house and the paddy field is about 100 meters, my lord. And PW3 says that I was at home when they dragged. But PW1 is, my lord, about 10 meters from the place of occurrence. So therefore, my lord, this version that PW1 saw that his brother was being chased because he was near the paddy field, my lord, just 10 meters away from, whereas PW3 was at home, 100 meters away from the place of occurrence. So, my lord, now in order to, my lord, here, my lord, firstly, my lord, the entire, my lord, the conviction and sentence, my lord, the judgment passed by the learned trial court, my lord, is based on this ocular evidence of PW1 and PW2, my lord. Now, I say that, my lord, that the learned trial court was, my lord, had rightly relied on the, my lord, the statements or the evidence of PW1 and PW2. Because in order to, the court had relied on the evidence of PW1 and PW3 for the fact that, my lord, whatever was stated during the chief as well as in the cross, my lord,
Yes.
nothing was, my lord, demolished or, my lord, any contradictions were brought about, my lord. Now, lordship will examine whether, firstly, my lord, whether PW1 and PW2 were an eyewitness to the occurrence, my lord. For that, my lord, my learned senior had read out the evidence of PW1 and PW3. Now, after reading this, my lord, the only, my lord, submission from my learned senior was that PW1 stated that he saw that his brother was being dragged, and PW3 saw that his brother was being, PW3 said my brother was being dragged, and PW1 said that my brother was being chased. That I have explained, my lord. I have explained, my lord. Secondly, my lord, kindly see my learned senior had also pointed out, my lord, that no motive was being brought out, my lord. Now, before making a submission to that, my lord, there is a slight hint of motive, my lord. Kindly come to Kindly come to page 35, the relevant portion of PW1 cross, my lord. I'll read the second last paragraph, my lord. May I, my lords?
Yes.
I do not know if my deceased brother destroyed the ripe paddy field of the accused.
Yes.
It is not a fact that my brother was not dragged from home on this date and time of the occurrence. It is not a fact that my brother and the accused were already in the paddy field prior to the time of occurrence as stated by me. It is a fact that my deceased brother created trouble and on time and occasion the Dadwa Shrong directed us to hand over to the... So there is a slight whisper, my lord, that I do not know if my deceased brother destroyed the ripe paddy field. So my lord, there is a hint here. Now, having said that, my lord, and I had earlier submitted, my lord, at the beginning, that even if, my lord, motive, in case of direct ocular evidence, my lord, motive, even if motive is not proved or brought out, my lord, it won't, my lord, in any way, my lord, the case of the prosecution, my lord, it cannot be demolished, my lord. Now, had it been a case of circumstantial evidence, my lord, for example, in case of last seen theory, my lord, this time, in case of, my lord, circumstantial evidence, my lord, the motive bears significance, my lord. The other, my lord, point raised by my learned senior was pertaining to the injuries in the post-mortem report, my lord. Now, as per PW4, my lord, the doctor who had conducted post-mortem on the dead body, my lord, has found that there was an incise injury, my lord. Incise injury meaning thereby, my lord, can be caused by some sharp weapon or object, my lord. So, the further submission of my learned senior was that, my lord, that nowhere in the evidence of PW1 and PW3 there is any mentioning of, my lord, weapon being used. Now, my lord,
No weapon seized.
no weapon seized, and the statement also does not say anything about that their brother was being attacked by any weapon, my lord.
Just come again to the opinion of the findings of the doctor.
Yeah.
What did he say? Cause of the death?
It is at, my lord, page 40, my lord, and the opinion, my lord, is at page 41. If I may read, my lord.
Yes.
External appearance, scalp, skull, vertebrae.
Last line.
Last line, my lord. Firstly, my lord, column 4 is important. Incised wound on the left supratemporal region measuring 3 by 2 centimeters, my lord. Now, in my opinion, the cause of death was due to hemorrhage resulting from the above injuries. Above injuries, my lord. But my lord,
If there's an incised wound,
yes,
that means some object must have been used.
My lord, if I may take a pause here, my lord. Kindly appreciate, my lord. The house from where, as per PW3, my lord, he was dragged, the deceased was dragged, and was, my lord, dragged, chased, as per the statement, my lord. He did not only use the word, my lord, dragged. He also stated categorically that my brother was further assaulted, my lord, by this. So he was, and then he also used the other term, then he was killed. So he uses three terms, my lord, that he was dragged from home, then he was assaulted, and thereafter he was killed, my lord, to the point of death. So, my lord, this is a continuous offence, and lordship will action, my lord. Lordship will appreciate that as per PW3, the deceased was dragged from the house to a distance of 100 meter, my lord, and it is a village area, my lord. So road cannot be smooth. So he was dragged, chased, assaulted, my lord. In the process, there is every likelihood of, my lord, banging the head in the floor, on the road, on the rock, though it is not in the evidence, my lord. But, my lord,
Where is the diagram of the PU?
'97. '97, my lord.
This is sketch map. You.
Paddy field, PO, near the wasteland.
Was it exhibited?
No, my lord. This was not exhibited. But however, my lord,
Not exhibited and not explained, I mean, not described also.
in this regard, my respectful submission would be, my lord, even if it is not exhibited, my lord, at the time of passing the judgment, my lord, it can be peeped into, my lord, for satisfaction. Though it cannot be relied on, my lord. I frankly make the submission, my lord. But however, my lord, for the satisfaction of the court, my lord, it can be glanced into, my lord. I think in the last occasion I placed a judgment on that in this regard, my lord. So, my lord, it was a wasteland, my lord, and as per the statement of the evidence of PW1 and PW3, my lord, that place of occurrence is 100 meters, my lord, from the house from where he was initially caught hold and dragged, my lord. So in the process, a person of common, my lord, average prudence can well, my lord, imagine or, my lord, make out that when a person is being dragged in a village road towards the paddy field for a distance of, my lord, 100 meters, there's bound to be, my lord, a fall, a chase, and, my lord, banging, dragging. These are all, my lord, continuous action, my lord, would ultimately culminated into the death at the paddy field, my lord. And that is not disputed, my lord. And no contradictions was brought out during the cross, my lord. So that stands, my lord, established. Now, about the, my lord, incise wound, my lord. From the very definition of the term incise wound, my lord, it cannot be caused by bare hand. It cannot be, my lord. But as I have explained, my lord, now in a case of, my lord, direct ocular evidence, my lord, my lords, if in the post-mortem, my lord, incise wound is reflected, and my lord, there is no whisper of weapon, and no recovery of any weapon, my lord. In this situation, what will be the, my lord, legal position, my lord?
Yes.
Eyewitnesses not stating anything about the deceased being, my lord, attacked with weapon. Further, there was no recovery of weapon, my lord. In this situation, what will be the legal position, my lord? According to my lord, understanding, my lord, in a case where there is a direct ocular evidence, considering the fact that they are rustic village people. Furthermore, my lord, their statements, evidence being recorded after more than 2 decades, my lord. So, my lord, these factors shows that, my lord, and this nature of
there has to be relaxation in the standard of proof. That is what you want to
exactly,
say.
my lord.
Law permits it.
Lordship.
Law permits it.
Lordship.
Law says that if any occurrence takes
Judgment
place
law says that, my lord.
it says that if occurrence takes place in rural areas, the standard of proof needed will come down.
My submission is not precisely that,
See,
my lord.
Mr. Guru, you are just do not argue something just for the sake of arguing. Just say us something which would have some.
Yes, my lord.
See, 2 things. Now you say that it has not been disputed that he was dragged. No, it has been disputed. The senior counsel has been submission is basically on that only. He said that one witness said that he was chased.
PW1.
And second is dragged. Now you
PW3.
you want that it was you are saying that it was not disputed. One thing is that it's not disputed. But anyway, you have a right to make a submission.
My lord.
But then
why I say not disputed, my lord? In the cross, whatever is
not needed.
Submitting
if 2 prosecution person gives 2 different evidence, that is good enough.
Exactly, my lord. But I think I have explained.
See, if you want to say that a person's evidence has to be disputed only in his cross, and if it is not disputed in his cross, even there is any other contra evidence given to any other witness, it will not be contradiction. Then that is.
It will be a contradiction. It will be a contradiction. But I think
now
I have.
You reconcile us. Your work is basically to reconcile. How do you clarify before us?
Yes.
That dragging part and that chasing part.
My lord, I think I have made it. I made a submission to that.
Your submission is on the assumption that he was.
Not assumption, my lord. It is on the record.
That say that he has not been crossed. See,
no,
since PW1 has not been cross-examined, so that is established.
My lord.
What about 3?
Yes, I am coming to that. My lord, PW1 says that I was at a distance of about 10 meters from the place of occurrence.
Where is that proof?
Yeah, my lord, PW1, my lord.
And then how do we presume that paddy field will be full of stones, uneven things? Paddy field, based on assumption, it will be grass, totally grass.
My lord, kindly see at the sketch map. Of course, my lord, just for the sake of my lord.
Sketch map you have never exhibited.
Exactly.
See, the loopholes in the prosecution case, as has been pointed out by the appellant, is that the injury which medical report projected, and also the broken skull.
Sorry, ma?
The broken skull.
My lord.
Skull. The contention made by the appellant is that these 2 injuries could not have been caused by bare hand.
Absolutely
now
correct.
You clarify on that.
Yes.
That is needed because you see the prosecution has not brought any evidence to show. See, doctor's evidence says that the death is because of the injuries. Doesn't specify which injury, whether it is incise injury or the injury which is on the head. Now it is for you to clarify.
Exactly.
See, the evidence, prosecution evidence has to be beyond reasonable doubt.
Exactly.
Okay, so that is what it should be. Now, you are basically trying to make an argument with due respect to you. You are just trying to, you see, like bypass touching the affairs, but then you are passing it.
I'm not passing it, my lord. I beg to differ, my lord. I beg to differ.
Then you just clarify on 3 and.
I'm doing that, my
evidence
lord.
Evidence of 3.
I'm absolutely, my lord. I got the query of this honorable court. I knew about it right at the beginning, my lord, which is why I made the initial submission, my lord. Kindly appreciate, my lord, here. I'm not saying anything out of the record, my lord. As per the statement of my lord, evidence of PW1, PW1 says that he is not at home, my lord. He is at 10 meters from the place of occurrence. PW3 says that I was at the house where the accused had, my lord, dragged my brother. And the distance from the house, from where it was dragged, the deceased was dragged, and the place of occurrence is 100 meters. So, my lord, what I'm trying to point out here is that whatever the PW3 had seen was at the initial stage right from home, which could not have been seen by PW1 because he was at a distance of only 10 meters from the place of occurrence.
So far as that evidence of PW1 cannot be believed.
My lord.
So far as that part of the evidence of PW1 cannot be believed. Cannot be believed. It has to be disbelieved.
Lord, yes. Lordship's opinion, my lord, I bow to that, my lord.
Was it that you are saying that? That means you are trying to say that the evidence of PW3 will override the evidence of PW1.
No, I'm not saying that, my lord. Kindly let me clarify, my lord. The place of occurrence and the house from where the deceased was dragged, my lord, there is a distance of 100 meters. It has come in the PW3 statement. PW3 says that it's a distance of 100 meters and I was at home along with my parents, and my deceased brother, the accused, came and dragged from home. Caught him and dragged him from home.
PW3 said dragged or PW said chased?
Dragged.
Who says chased?
PW1.
One says chased. Yes. Probably.
PW3 says chased. PW1 says dragged.
Yes.
So, my lord, kindly see. Let me come to PW1 first. I know all the accused, page 33, my lord. I know all the accused persons who are present in the court today. One Sadamuru, who is now dead, was my younger brother, who died on 16/11/1991. He was murdered by all the above accused person. I saw the occurrence myself. The occurrence took place around 6:30 to 7 p.m. on the said date at the paddy field belonging to my mother, so-and-so, at Lumkudung. Immediately after the incident, I asked them as to why they killed my younger brother, who was not mentally sound.
That part you will find in cross-examination.
Yeah, my lord, just to go with the flow, my lord.
Just come to the lower part of the same page.
I was cross, my lord.
Yes. After a second, just read the first two
I
lines.
reached home on 16/11/1991 at about 6 p.m. The paddy field of my mother is at Lumkudung village and met at Sung Valley. From Sung Valley, I reached my house first, then the paddy field of my mother. On reaching home, I took my meal and get ready for bed. Then at the time the accused came and dragged my brother to the paddy field of my mother. So, my lord, here, my lord, before I go further, my lord, PW1 clearly states that he was at home and his brother was dragged from home. At that time, my brother Usadamuru, so-and-so were also present at home. Then we did nothing to follow the accused along with our brother Usodamuru and asked them not to beat him. The distance of the paddy field from our home was about 100 meters. Kindly, my lord, we'll try to connect it, my lord. I'll repeat again from top. Then we did nothing to follow the accused. They did not follow. And now he further says the distance of the paddy field from our home is 100 meters. So, my lord, here I'll take a pause, my lord. That what PW says is that he was at home, the accused person came to his house, and his deceased brother was dragged from home, dragged. And they did not follow till the place of occurrence. What I'm trying to, my lord,
That is
clarify.
What, you see, that is what the case is. That is what has been held by the trial court also.
No, no,
Isn't it?
my lord, right now,
if you now see,
right now the
one
query
can-
of my lord was about the dragging and chasing. I'm coming to that, my lord. I'm not going to the judgment right now. Lordship had, my lord, asked me to clarify about these contradictions, chasing and dragging. So, now I have come to the dragging part. PW1 states that my brother was dragged from home. But where he was killed is about 100 meters away. my lord. So, what I say that, further he says that we did not follow the accused and the deceased till the place of occurrence. So, what I am saying here is, my lord, that he witnessed the initial part when he was grabbed and taken out from home. But PW3 says that, my lord, he is only 10 meters away from the place of occurrence. That means he is not at home, near home, but he is.
So your explanation is something like that.
So, my lord,
That initially he was
dragged.
and then subsequently changed.
No, my lord. I'm not saying that. What I'm saying that is, my lord, PW3 is at a distance of 100 meters from the place of occurrence. PW1 is at a distance of 10 meters. Therefore, whatever they, my lord, witnessed cannot be the same thing.
Different.
Because he was assaulted, he was beaten up, he was dragged, he was chased. What PW1 says that I saw my brother being chased means the person, probably in the process, my lord, he was dragged by 5 accused person. So there is every likelihood he will try to save himself. And in the process, he might have witnessed, my lord.
That is what.
Exactly,
See,
my lord.
for some part he was dragged and maybe he tried
Yeah.
and he changed.
Because PW says, my lord, not only dragging, he was assaulted also. Now ultimately says he was killed also, my lord. So, my lord, 2 persons at nearby location, a particular location, different distances, my lord. So, therefore, my lord, their statement cannot be same, my lord. Had it been same, my lord, then there should have been doubt, my lord. Had it been same, then there should have been a doubt.
When was this accused person arrested? On the same day.
My lord.
In the judgment, it reflects on 1911. That means day after the affair.
Day after the occurrence.
Day after the date of FIR. Occurrence is 16.
Occurrence is
FIR
16, my lord.
18,
Yeah.
And arrest.
No,
on
no,
19.
FIR is 16 itself, my lord. There is some my lord, kindly look at the FIR. I'll come to that later on.
Anyway, what I would like to know is, after they were arrested, were they, examined medically?
That is not there here, my lord.
See, what is the medical report says? Any signs of injuries in their hands or face? Or
For that, my lord, in that, this is getting very interesting, my lord, it is going in depth. So in that scenario, my lord, if I may pray, my lord, I may be allowed to go through my lord, this AC record is there. AC record is there. It has been called. AC record. CD. Whether this is complete or not at the moment.
CD will be there, and record will be there.
Well,
But you see, if there is no weapons found, he must have been killed by something. If it was just by fist or by any kind of object, or most probably should be assault by fist. So
something maybe.
that should be reflected in the medical examination of the accused.
Well,
so also was found with some bruise or something in the hands or whatever. That should be there.
Even in the worst scenario, my lord, even if that is not there, my lord, then, my lord,
Even we
so
can
in that, I'll go through, my lord.
conclusion will somebody has to make some conclusion or some.
My lord is absolutely correct, my lord. That is, of course, there has to be something there, my lord. If at all it is there, my lord, let me go through once, and I'll satisfy your lordship with whatever.
We'll stop here. Heard Mr. S. Chakravarti, learned senior counsel for the appellant, who has concluded his argument. Also heard Mr. R. Guru, learned GA for the state respondent. Hearing is not concluded and will continue on the next date fix. This is matter to we'll fix it next week.
Diplomacy.
Speaker again, sorry. It's 10th.
Diplomacy.
This is matter.
Obliged. Obliged.
Item number 5.
Whatever, he is not, other side is not appearing, but Miss Case 147 2025, I have no objection for deletion. He is not appearing.
You are making submission on their behalf as well as on your own.
No, I have no objection. If your lordship allows this.
What was the prayer?
Miss Case.
What was the prayer?
Miss Case for deletion of the petitioner number 147. Then matter may be fixed next date for
Miss
hearing.
Case?
Miss Case 147 or 2020.
Miss Case is there in the list.
140,
Yes.
item 14.
What difference it makes, controller and deputy controller?
My lord,
Any material difference in the thing?
comptroller, they are saying that comptroller of Auditor General is not looking after the service pieces entire. He is an administrative control is on deputy accountant. So they want that it is be deleted. I have no objection because he is not here. Then matter may be fixed for hearing next day.
Do you have to amend the constitution? That is.
It is not like that.
No, leave it.
See the prayer language. It's not to allow them to amend.
Yeah, we allow. Yes, miss, where were you? Take your time, take your time. You don't need to say anything, just stand still. We may dismiss your case. No, will not. Miss Leonard Counsel is present on behalf of the petitioner. Sorry, present petitioner and applicant. Mr. Esnat, Leonard Counsel for the respondent, has submitted that as far as this instant application with the related prayer for amendment of the cause title of the main application insofar as the name of the original petitioner. Is it writ appeal or appeal?
Petitioner, Lordship.
One.
It's insofar as the original petitioner number 1, the Controller and Auditor General of India is concerned, to be deleted from these proceedings. There is no objection to the said prayer by the respondent. Accordingly, on consideration of the submission made, this court hereby allows this application, and the name of the said petitioner oblique controller and auditor general is hereby deleted from these proceedings. The petitioner is allowed to amend the cause title accordingly. Decision disposed of. It's not there. How many? Was you want incorporation?
The substitute, Your Lordship.
Yeah, so it's question of substitution. I thought it's only here. Yeah. Oh, M and Omni. Accordingly, as prayed for, the original petitioner number 1, that is Controller and Auditor General of India, is to be replaced by the Deputy CAG. Petitioner is directed to take steps for amendment of the cause title. Decision disposed of. Atau you boleh pemimpin case this is matter after 2 weeks.
Oblige.
Just some confusion. If he is already included.
Yeah. Just me. This one.
Was there an implement before this matter?
Yes.
Was there an implement application in this case?
None.
Your Lordship. Substitution,
What
Your Lordship.
what your come to the reverse, the second page of the your miscase number 147. See the cost title.
Yes, Your Lordship.
And what does it mean? Included as petition number 1, white order dated 14/5/2005.
Yes, Lordship.
What is it?
Have you found it?
Yes, Your Lordship.
This is same person. If he's already included, then why should he?
Yes.
Lordship.
What does it mean? If he's already implicated, then why do you need the miscase?
Lordship, this order.
No, he is already there. Your petitioner number. It is 147.
Yes.
It is 147.
Yes.
Then your application is praying for amendment cost title.
Amendment of course title, Your Lordship. Amendment of course title, Your Lordship.
And already.
There appears to be some confusion, Mr. Nath.
Yes.
We do not know that. You can clarify us.
Yes.
Yes.
If the person already stands implemented,
Yes.
now
No
there is
need
no
to.
question he replacing some other.
None.
Sorry. Again, there is some confusion here. Let us see. Yes. Oh, yes. Same. Yeah. 427. So this is the 427.
Yes.
So in the same case,
Yes, Your Lordship.
yes. Where is the order dated 14/5? So this is by this order you have been allowed to file the application.
Yes, Lordship.
So, again, this is the application.
Yes, Your Lordship.
But I think your wordings are not correct.
Yes, Your Lordship.
That's what, by this.
It is because of your wrong choice of word.
Yes, Your Lordship. Confusion.
See? So that order stands.
All right. Petition ML miscase
please, Lordship. Lordship, would like to make a joint mention of item number 3 in law. Matter is fixed for filing of written arguments, Lordship. Requires some time. Matter may come up after 2 weeks, Lordship.
Prepared by the prepared by learned counsel for both the parties. That is adjourned. Discussing after 2 weeks.
2 weeks. Obliged, Lordship.
May it please your Lordship. Lordship, I beg to make a mention of item 1 and 2, Lordship. These are connected matters. They are part heard matters, Lordship. These two matters have been heard.
19 matters.
Lordship, these are partly heard, Lordship.
True.
Lordship.
That is why see, once they are partly heard,
Lordship,
means this court has at least gone into the matter.
Lordship.
Now next time around, you have to start afresh.
Lordship, I'm just praying for a short day, Lordship, in this matter. Today, I'm having some personal difficulty, Lordship.
Miss Leonard Counsel has sought for accommodation on the ground that she is not prepared to be heard in this matter today. As prayed for, matters adjourned. This is after 1 week.
1 week, Lordship. Highly grateful, Lordship.
On supplementary list, item number 1.
Lordship, this is an application under 482 of BNSS. We are coming for anticipatory bail, Lordship. It's an application under 482 BNSS, anticipatory bail.
What is the case about?
Lordship, if I may appraise with the brief facts, Lordship, this case stems out of an FIR dated 14th of September 2024, which was lodged in the Damalas MPS. Lordship, the FIR, Lordship may have it at the type copy is at Lordship page number 18. Lordship, in this FIR, it was alleged that on the night of 12th September 2024, some unknown culprit brutally murdered one Karak in Sangma and dumped the dead body on the roadside of Mangakre village. Now, upon filing of the FIR, Lordship, a case was lodged, Lordship, under 103 of the BNS for murder, and the investigation commenced. Still, Lordship, the case is at the investigation stage. There is no arrest has been made. Now, Lordship, what had happened? This particular FIR was lodged in the month of September. After 10 long months, Lordship, in the month of July, for the first time, Lordship, an eyewitness suddenly emerges and takes the names of 6 persons, including 3 petitioners who were in front of Lordship. Now, for the first time, Lordship, this eyewitness after 10 long months takes names of 6 persons and the police starts hunting them down. Apprehending arrest, Lordship, all these 6 persons approaches the learned DSJ Tura and for anticipatory bail, Lordship. Thereafter, Lordship, they were granted interim protection. They appeared before the IO, they are on board the investigation, their statements were recorded. However, eventually, Lordship, VD order dated 21st August 2025, all the 6 applications are rejected, Lordship. Now, Lordship, since I am coming under concurrent jurisdiction, Lordship, after suffering a rejection, Lordship, I would like to draw one particular attention, Lordship, to a background of the petitioner number 1. Lordship, what happened? The petitioner number 1 is a public spirited citizen. He has been involved in several, very at the village level, not at some higher level, Lordship, at the very rudimentary level. He has been involved in some community services, local developmental activities. What happened, Lordship? Sometime in the month of July, this petitioner number 1 became very vocal about the local issues. He had started raising questions about the maladministration going on, about the corruptions, local corruptions, why there is not basic healthcare facilities, no educational facilities. And in this effort, Lordship, the other petitioners were also in support of the petitioner number 1. Accordingly, all of them came into the public sphere. Basically, Lordship, what the petitioners did, they had upset some people who now wants them inside, behind the bars to shut their mouth off. That is the basic facts. Now, Lordship, if I may draw Lordship's attention to some parts of the order, since the CD is not here, Lordship, certain parts of the order, Lordship, order of the learned DSJ, Lordship, if Lordship may kindly have page number 28, Lordship. Yes, Lordship, page number 28, first paragraph, I am reading from fourth line from the bottom, Lordship. From the CD, there is reason to believe that witnesses have been subjected to threat to their life, which also explains the fact that initially none of the witnesses are willing to reveal anything. Now, Lordship, this particular observation that initially none of the witnesses are willing to reveal anything, the purport of this particular observation is, Lordship, the statement of the eyewitness in this case, Lordship, was recorded 4 to 5 times. And in all these statements, the eyewitnesses clearly stated, which in fact corroborates the FIR, that I do not know who had committed the crime. Suddenly, after 10 long months, Lordship, these 6 names were being Lordship, there are already on record exculpatory statements insofar as the petitioners are concerned. And not only the eyewitness, Lordship, even the other witnesses. There is only one eyewitness. In the other eyewitnesses, Lordship, they have several initial statements. They have clearly revealed that I do not know who have committed the crime. Subsequently, Lordship, these 6 names, they were coerced under duress. They were forced to take these 6 names. And secondly, Lordship, if I may draw Lordship's attention to another observation, Lordship, and in that particular paragraph itself, Lordship, in the opening lines, it is pertinent to note that...
you tell me where is your source of apprehension?
Lordship, my source of apprehension being, when I moved before the learned DSJ Tura, there was a strong objection from the IO. And secondly, Lordship, when I suffered the rejection...
Even before you move for your relief before the Tura court.
Tura court, yes, Lordship.
There must be something.
Yes.
Did it emanate from the statement of the eyewitness or
statement of the
police came looking for you, or
after Lordship, the statements of the eyewitnesses were recorded in this manner. Police came and police is making rounds. However, now, Lordship, after suffering rejection, what the police has...
How do you know?
Lordship,
how did you come to know that police are looking for you in connection with this case?
Lordship, they were coming and asking about us in the village, Lordship. That is how we came to know that they are looking for us, Lordship. Now,
but you will not know what the eyewitness say, what he stated before the police. You
no, Lordship. But our
saying that the eyewitness has...
Lordship, because of DSJ's observation, Lordship, because there is one observation, Lordship, page 27, Lordship, last paragraph. Because of that we are saying, on perusal of the CD, if I may read, Lordship, page number 27, last para, Lordship. Heard submissions from both sides and perused CD, and on careful perusal of CD and report, there is reason to believe that all petitioners are involved in assaulting of so-and-so with dangerous weapon after killing victim, all petitioners. That is why, Lordship, from there I could filter it out. That
even then, this observation would come after you have approached the district judge.
Yes, Lordship.
Sessions judge.
Yes, Lordship. However, Lordship, in this case, after suffering the rejection, Lordship, what has happened? The police have set up a camp outside the village, Lordship.
Yes, Mrs. Singh, what do you have to say?
My Lord, the rejection order, the page number 28, my Lord, it categorically states, my Lord, in the
this
first paragraph.
This order is not in appeal or revision.
My Lord. Moreover, my Lord, may kindly see the content of the FIR. What is the case all about, my Lord? This is a FIR dated 14 September 2024, my Lord. It says this has been filed by Litnath M. Sangma.
Yes.
Before the officer in charge, Damal Asim Police Station. It says, my Lord, with reference to the subject cited above, state that on 12th September 2024, night some unknown culprit brutally murdered late Karak M. Sangma, son of so-and-so, and dumped the dead body on the roadside at so-and-so village. Therefore, I would like to request you to kindly investigate and look into the matter. Now, one person, my Lord, has been brutally murdered and thrown in the roadside, my Lord. Now, the investigations was on, and then, my Lord, initially, my Lord, none of the witnesses, as per the record, my Lord, because we have not called for the CD, my Lord, so as per the record, what it shows, my Lord, that witnesses were not cooperating initially, my Lord, because there is a great threat to their life. The threat was given, that it transpires from page number 28. I'll just read out the relevant portion, my Lord. Page number 28, it says, my Lord, I'll just read from the third line. From the CD, it is seen that they deny knowing the victim, though 5 of the accused persons are from the same village, so-and-so, as the victim. All the petitioners have claimed that they were never in contact with the victim, and whereas prior to the incident, the CDR of the victim, it was found that the Chunky and Sangma, Tinet B. Marak, Dilak B. Marak were in contact with the victim. This shows the untruthfulness of the petitioners, which raised a very strong suspicion. From the CD, there is reason to believe that the witnesses have been subjected to threat to their life, which also explains the fact that initially none of the witnesses are willing to reveal anything. Therefore, safety of witnesses is paramount and custodial interrogation necessary. Now, my lord, initially because of their threat to their life, my lord, they have not opened up. However, my lord, subsequently they have given their statement, wherein, my lord, this name of these petitioners herein, my lord, that has been revealed, that they were the one who has done the murder. In such circumstances, my lord, I have strong objection, my lord, granting pre-arrest bail. My lord, this is not a case where the bail should be granted, my lord.
Yes, no, CD has to be called for.
Yes, Lordship. CD be ready.
Mr. Counsel for the petitioner was submitted that the petitioners herein have approached this court with this instant application under section 482 of the BNSS with a prayer for grant of anticipatory bail. It is next. It is a submission of the counsel that on an FIR lodged by one Sri Litnath M. Sangwa on an FIR dated 14/9/2024, lodged by one who has informed the police of the case of death of one late Karak M. Sangwa, who is said to have been brutally murdered and thrown on the roadside at Mangagre, the police have registered a criminal case being Daman Asim PS case, Damal Asim PS case number 29/24 under section 103 BNS. Since then, the investigation has been going on for the last 10 months or so, and it was only after such period that the petitioners herein came to know that they have been implicated in the case, since the police have come looking for them in the village at the place of residence. Accordingly, all the three petitioners herein have moved the learned sessions judge at Tura, West Garhwils district, for grant of anticipatory bail, which prayer was rejected by order dated.
Lordship, 21st/8/2025. 21st August, Lordship.
21st August 2025. Hence this petition. Mr. Ensinkon, GA has accepted notice on behalf of the respondent. As such, no formal notice is required to be served upon the said on the said respondent. The learned GA has at the outset strongly opposed the prayer made and has referred to the said order dated 21/8/2025 passed by the learned sessions judge, which order is also annexed in this petition, as Annexure 4. Annexure 4,
Yes, yes, Lordship.
page 24. And I submitted that from the contents of the order, what emerges is that the eyewitnesses who have witnessed the deceased being murdered have named some of the perpetrators, including the petitioners herein. As such, on this ground and several other grounds, the said application was rejected. Accordingly, since similar prayer has been made in this petition, it is the submission of the GA that this application may be dismissed at the threshold. This court has given consideration to the submission made, and on the basis of the materials on record and the submission of the parties, is of the opinion that the petition may not be dismissed, may not be that the prayer of the petitioner may not be decided at the outset without producing the related case diary. Next, accordingly, the prosecution is directed to produce the relevant case diary on the next date fix. This matter on 11th?
11th.
This matter on 11th for
Obliged, Lordship.
Item number 2.
Please, my lord. In pursuance to my lord's liberty, we had filed that affidavit bringing on record the public notice. Oh, I'm so sorry. So that I had filed that affidavit.
But,
is it required to be?
For my learned friend starts, my lord, Dr. Mozika is leading in this matter, my lord. Your lordship, this matter is he's before the court for one.
Request to me also.
We may not, if this application is required to be heard.
Have it tomorrow, my lord, then?
No, my lord.
Because
in fact,
the only
my
thing
lord,
is, see,
in view
public
of
notice
the-
has been, public notice has been brought on record.
Yes, my lord.
It's for you to say whether it's correct, not correct, or you admit that it has been so published.
My lord, we will file, we can file a reply to this, my lord. But the point is, my lord, the issue, my lord, issue herein is seized by the Honorable Supreme Court, my lord.
No,
and propriety demands, my lord, that this Honorable Court should not.
Definitely.
Yes, my lord, because if your lordships kindly have. I'll have to file a reply because I'll have to bring to your lordship's notice one publication by them in a newspaper, my lord, regarding the notice issued by Supreme Court. It was in pursuance to that we have issued these these orders, my lord.
That is I mean, in the Supreme Court. It is for
the subject matter is the same, my lord.
Is for issuance of a notice upon some respondent.
UGC, my lord. But the subject matter is the same, my lord.
Subject matter.
My lord, here they say 6,000 students. In Supreme Court, they say 9,000 students. So, my lord, so that issue regarding the students is seized by the Honorable Supreme Court.
You file your response. Then.
We'll file a response.
But there is what I am because my learner senior friend here asked for having accommodation for till tomorrow. So that is the reason I did not open my lord brief. Otherwise,
but he would.
My Mr. Musika has requested me to have it tomorrow because
even
Honorable the Chief Justice.
Mr. Singh, even if we have it tomorrow.
Yes.
What happens is.
I have got a different submission.
Even if we come back tomorrow.
Yes.
The other side will still say that they need time to file a response.
Yes,
to this.
I have got a different submission, my lord, on that count, because my lords may recollect that the learned ASG Advocate General, Additional Advocate General, made a statement on bar that they would not persecute this particular matter, my lord, live further. And on that assurance, and my lords also observed that since he is making this observation, we don't need to pass any kind of order on the stay application. And that is the reason only the notice was issued. Now, what happened thereafter? Now, kindly have this affidavit. If my learner senior friend wants to argue, my lord, I just have this public notice. And the date is important because the date is 20th August. The covering letter is at page, my lord, first of all have the covering letter which is at page 12 and the typed version is page 13.
Lord, before that, my lord, since the inception of this matter, I have been appearing, my lord. What submissions is my learned friend making regarding double AG appearing and making some...
Not the double, Mr. Mozika did appear.
He's not appearing as double AG.
No, my lord.
As a special counsel also, he was there, my lord, on 31st of...
No, whatever the case may be.
31st of August, he appeared and assurance given to this honorable court was that they would not precipitate the issue. And on that assurance, my lord, my lords were only... I did not argue and did not argue on stay.
No, in the meantime,
yes,
the order of the Supreme Court came.
Yes.
No, kindly have. Thereafter, my lord, the order of the Supreme Court my lords are right. Actually, the Supreme Court order is passed. Supreme Court issue is slightly different from what issue we are prosecuting here. Let me.
No, Lord, I'll file my affidavit.
My brief, I know what I've been arguing there, what we are arguing here. If my learner friend wants to take over the matter, my lord, good enough. But kindly see the dates is very important because what has happened, this public notice is issued immediately after the issuance of notice by the Honorable the Supreme Court, where they appeared also through their senior counsel, and despite their appearance, my lord, the UGC was impleaded because it was held that the UGC is the only necessary party in the review petition, because now they want to see the future of the students also. Immediately, my lord, kindly this notice is issued, and kindly see, my lord, what they do is, I'm more aggrieved by one, the assurance being given to me, and then this issuance of public notice at page 9. Just have this public notice, my lord. This is dated 21st of August, and covering letter is at page 13 to some department to publish it in a newspaper. What is, kindly have the last para. The third para, my lord, whereas the Supreme Court, through its judgment dated 13th Feb, has passed a ruling in favour of the state government of Meghalaya and has upheld its order for the winding of the CMG University. Whereas by notification dated 20th of February 25, the government of Meghalaya, through its education department, so and so, appointed Shri Lingdo, Joint Secretary to the Government of Meghalaya, as the administrator of the CMG University Meghalaya. And whereas the administrator issued a public notice dated 26th of March 2025 for winding up of CMG University, thereby commencing the formal process of its dissolution and inviting claims and objections from all concerned stakeholders. Following the first public notice dated so and so, so many people appeared. 987 queries concerning CMG universities were received, which have been duly responded to and forwarded to the university's registrar in compliance with the order dated 24th of April. These queries fell under the categories of academic document request, including degree verification, certificate procurement, and document submission, PhD related queries such as thesis evaluation, request for degree certificates, and grievances and journal inquiries covering claims on the degree validity and student status inquiries. Now the administrator of CMG University informs the public that the last date for receiving queries, grievances, and claims related to CMG University is 5th of September. Kindly mark this date, my lord, because now they are wanting date. This decision was made during a meeting held on 28th of July in the presence of concerned individuals from the government and the members of the CMG University administration to ensure all outstanding matters can be settled before the final dissolution of the university. Key information for the public to note: all academic activities of CMJ have been stopped since 15th of February in compliance with the Supreme Court's order 2014. No verification, authentication, or validation of degrees will be carried out. Any degree issued in after 2014 shall stand invalid. as the university could not have had these students continuing in view of the stay order of the Supreme Court. I pause here, my lord. Now, this is the precise issue before this honorable court, and some part of it is in the Supreme Court also, where the Supreme Court has issued notice. Now, if this is allowed to continue, my lord, what will happen is all these degrees, my lord, automatically becomes invalid. While my lord seeing of the matter, statements are made on the bar that no, it would not be precipitated, yet now this notice does not, my lord, include, it is issued on 20th of August. It does not include the notice of issued in the review petition as well as this honorable court also. Had it been included, madam, I would have got still not, my lord, pursued my matter here. Now it does not include, it goes in a vice because the dates are very important. Moment the Supreme Court issued notice, they issued this public notice. And not only this, my lord, now I have come to know, they have issued this, my lord, public notice in the newspaper itself. Even before, now at page 13, they are asking a department to issue the public notice. Kindly have in Manipur, they are issuing this notice altogether in the newspaper. In some newspaper called Pokna Pham Edition, Imphal. This notice is already issued altogether. Without the Director of Information and Public Relations Meghalaya any intervening, or because the page 13 says the administrator writes to the Director of Information to publish this newspaper in all the leading newspapers. Whereas this notice has already been published by him, signed by the administrator himself. So there is some malice, my lord. I am saying that in case they want the time, my lord, I got no problem. But then it cannot be, my lord, precipitated any further. This public notice has to stop because of the judicial proprietary demands as well. Supreme Court is seen, whereas the categorically issues are my lord, issues are framed. They are party to it. This honorable court has also issued notice on stay also, and the statement on the bar. In all fairness, my lord, I am only saying that let the administrator not do any or precipitate the issue any further, and let this public notice be stayed till the time this honorable court decide, or the Supreme Court, whichever my lords may, my lord, feel, because there are some overlapping issues. So grateful, my lord.
I think so. I'll file my reply, my lord, by shouting.
But fifth, I don't, my lord, I'm not shouting at all. I'm arguing. Why my learner friend knows me. I've been arguing like this all over the country, and he's also following me in some of the matters. I don't need to shout in every court.
Following you in shouting or following
Well, I'm arguing. I'm still arguing. My shouting is very different.
The whole courtroom is shaking, my lord.
Very well, my lord. I can reduce my volume, but that doesn't mean that I start shouting.
So my lord, I'll file a reply.
5th of September, kindly note.
You file a reply, we'll take up this matter tomorrow.
Yes.
Very well. So grateful, my
lord. My lord, may I have it?
No, tomorrow.
5th of September is the date, my lord.
Otherwise, I'll pass an interim order to you.
My lord. My lord may hear on that, my lord.
Grateful.
Because ideally, my lord, all these facts should be placed before the Honorable Supreme Court.
Whatever the case may be, see,
yes,
we are as of now, matter is not finally decided.
Yes, my lord.
But as Mr. Singh has said, you see, propriety demands that we act accordingly.
Yes, my lord.
You cannot just, bulldoze something, or you cannot just sidestep something. Do it properly. Everyone is, has to take that responsibility.
Lord, in case I'm not able to file it tomorrow, Lord, your lordships will hear the matter.
And
in the event I'm unable to.
Either that,
yes.
What we can do is this court will allow you to file if you want. Even today, the order can be passed.
Yes.
Allow you to file a response to this, but this public notice will be stayed for it.
My lord.
We'll do that. Heard Mr. Singh, Direct Counsel for the petitioner, who has centered his argument only on the contents of the affidavit dated 2/9/2025, wherein by way of the said affidavit, the petitioner has brought to the notice of this court the public notice dated 20th August 2025, issued by the administrator.
Administrator, my lord.
Administrator, CMG. What is the subject matter of this notice?
My lord, this notice wants to invalidate all the degrees, my lord, of all the students passing from 2014 onward till date.
In short, the purport of the notice is to invalidate all degrees issued in or after 2014, issued by the university, by CMJ University, in or after 2014. And the last date for receipt of any queries, grievances, etc. and claims have been fixed as 5th September 2025. It is precisely because of this timeline of 5th September 2025 that the Learned Council has expressed its apprehension that proper procedure has not been followed in spite of the ongoing, in spite of the presence of this petition before this court, which is yet to be finally heard. It is prayed that in the meantime the operation of the said public notice be stayed. Mr. Philemon Nombri, Learned Counsel for you are for the
state, for all the respondents.
For the respondents, has submitted that he may be allowed to file a response to the said affidavit, for which some time is prayed for. Accordingly,
till tomorrow, my lord. Time till tomorrow.
You want to, if you want it till tomorrow, some other day. Otherwise,
till tomorrow, because I will be advising the department also, the administrator, to put this on hold or to extend the date at least, my lord.
Exactly.
So let it come up tomorrow, my lord. Let me just speak to them. I'll speak to them.
Tomorrow. This one night for which sometimes before. As agreed to by parties, place this matter for the hearing tomorrow.
Tomorrow.
Great.
I will not make any observation on your.
No, my lord. No.
Tomorrow we'll see how.
I will advise them accordingly.
You do that. You come with some instructions.
Yes, my lord. On fairness, I will always do that.
Please.
Grateful, my lord. Deeply.
And I apologize, my lord. I don't shout, my lord. I'm just arguing.
It's slightly loud.
I may be loud, my lord, but that doesn't mean I'm shouting, my lord.
Because I'm too scared of your shouting.
I apologize, my lord. I'll try to tone down, my lord, myself. Then I will miss an argument or two, my lord.
We all have our own individuality, so.
My lord, may excuse me, my lord. I'll try to tone down, my lord. But I will miss some arguments, my lord, in case I'm not making it in a passion.
Lordship is a very soft person.
I am well aware, my lord. I apologize.
As long as no disparage comment is made against me, fine.
I am grateful, my lord, for hearing us.
Daily list, item number 4.
I will take some time, my lord, whether your lordship.
Yes.
I will take some time, my lord, to finish.
What is required here?
My lord, the only thing is half of the matter. My friend has already argued the matter. I have argued it halfway last time because your lordship have to rise to sit in the DV. So two of the grounds have already been covered by me. So 2 more grounds are there for me to cover. 4 more grounds are supposed to be covered by me, my lord. So it'll take some time.
Next date.
Because your lordship also will be sitting in the DB most probably.
On payment by the parties, this is matter after 2 weeks.
Oh, lordship.